Sound cuts in, raw and immediate, a single harsh intake of breath, then a paper slap on wood. $5 million bail offer, a voice reads, flat. The words drop into the silence like a stone. Free or safe? The microphone carries everything. It carries the scrape of a pen. It carries a man's practiced laugh, muffled behind glass. It carries the soft, fast typing of a reporter feeding the airwaves. It carries a chair that's pulled back, close enough for a whisper. Outside, people are already shouting into their phones. Two slogans fight to be louder. Free hail. Keep us safe. The audio feed is a battleground. You do not see Victor Hale at first. You hear him. A suit that knows how to sit still. A voice that knows how to apologize without regret. He sounds like a man who has never been stopped by consequences. Judge Rowan does not raise her voice. She inhales. You hear it. Long. Deliberate. She leans toward the mic and makes the smallest sound anyone in the room can hear. Free or safe? The question is not rhetorical. It is a choice offered to a public hearing. It will be answered in papers, in arguments, in GPS pings, in the thin thread of proof that ties a man to a crime. It will be answered outside this room by tweets and by neighbors and by the quiet, terrified voice on a recorded page. The envelope remains closed. The audio feed keeps running. Hashtags flicker to life. Fecker free hail. Ek keep us safe. Free or safe? Clerk Maya lays the exhibits on the bench with the exacting care of someone who has seen disorder before it arrives. Paper edges meet paper edges. A pen clicks. A reporter in the back clears a throat. Somewhere beyond the courthouse walls, a radio breathes the headlines into the room. Victor Hale is a name the city knows by invitation. Gala photos, philanthropy dinners, plaques with his name set into marble. That is what the public sees. What the prosecution brings forward is quieter and harder to look at. A pattern, a series of small dominations that, over time, add up to control. Michael Rourke does not raise his voice. He moves like someone who has trained himself not to be heard until he needs to be. He thumbs through a slim stack of documents and reads, not theatrically but with a blunt economy. Medical notes, a clinician's summary that uses the clinical word, strangulation, along with dated entries that show cards closed, accounts altered, access revoked. The ledger reads like a slow narrowing of exits. Maya slides a printout across the bench. It is a medical photo, cropped to the neck and forearm, careful to avoid the face. There is no sensationalism in the image, only the small, stark evidence of pressure and bruise. Rowan takes it without haste. She breathes in a quiet breath and studies the image by leaning her head, as if she might find a margin note in the light. For the first time, a tiny contraction passes across her mouth. Her pen hovers over the page and then taps, twice, a metronome for gathering thought. Victor watches the exchange in a way that does not demand attention, but earns it. He is composed to the point of performance, a slow tilt of the head, a finger to the cufflink, a minimal smile that does not reach his eyes. When Rourke names the specific clinical indicators, Victor's mouth tightens imperceptibly, half a smile, half a challenge. Rourke looks up and meets that small motion with a steadying look. No word passed between them. The look is enough. In the audio feed, the small sounds register. The rustle of paper, a pen cap removed, the soft inhale of a room holding its breath. Rowan's hands are steady, but a memory slides across the room like an old photograph. It arrives as an action rather than an explanation, A tightened grip on the pen, a quick, controlled exhale, a single line of her jaw that sets. She does not narrate that past. She acts from it. The present requires precision, procedure over impulse, form over flourish. Rourke outlines the procedural tools he intends to seek. He names GPS ankle monitoring and regular reporting to probation. He mentions travel restrictions and the surrender of a passport as measures to reduce flight risk. He speaks of a restraining order and of enrollment in a state-certified batterer intervention program as conditions to keep a complainant safe while the case proceeds. His language is practical, the language of instruments rather than of outrage. Victor's counsel leans forward in a low murmur. Lawyers trade paper and soft gestures. Outside the room, the city's chatter threads through the windows. "Free him," someone snaps. "Keep us safe," replies another. Those fragments fall into the audio feed like rain into a pool, ripples that will reach further than this room. Maya meets Rowan's eye and gives the smallest nod. "Victim advocate identified," she murmurs. Rowan replies with a word that is more assignment than comfort. The judge's voice is not for broadcast theatrics. It is for making the machinery move. On the bench, the documents make a quiet authority. The question they represent is loud. What does liberty mean when measured against a demonstrated risk? The room waits, the audio feed records, and the public beyond the doors begins to line itself on either side of a very narrow decision. If you want to follow the full hearing, subscribe for updates. The testimony is next. The decision is not yet. The tap of the gavel is smaller on the feed than it sounds in the room, but it declares the proceedings the same. Microphones are live. The court allowed an audio-only pilot. No cameras, no images, only sound. That fact shapes every choice made in the room. Words land differently when they know they will be carried into other people's kitchens and cars. Rowan speaks first. Her voice is unadorned. "We will proceed on the record," she says. "This is an audio pilot. No video." The words close the door on spectacle. They shift the contest into cadence, into fact, into the careful choreography of testimony. A cough, the flip of a page, the soft thump of a binder. These ordinary noises become part of the public record. Rourke stands and delivers a measured outline. He speaks of instruments, the GPS ankle monitor, regular reporting to probation, surrender of passport, travel restrictions, a restraining order, enrollment in an anger management and coercive control intervention program. He frames them as tools the court can use to manage risk during the pre-trial phase. When he speaks of the ledger entries and the clinician's assessment of strangulation, his voice tightens in a way the audio catches like a string pulled taut. From the dock, Victor emits a small sound, a breath that is more a tightening at the back of his throat than any full expression. It is easy to miss on a first listen, but it is also the sort of thing the microphones pick up. In the front row, a young paralegal shifts and swallows audibly. A veteran reporter in the back straightens as if the air itself changed. Rourke gives a slight eye to the dock, a factual acknowledgement, nothing more. The exchange is tiny, almost a punctuation mark, but the room registers it, the feed records it, the audience beyond the glass will replay it. Lionel Mercer watches all of this with a quiet, deliberate attention that reads like strategy. He does not interrupt. Instead, he makes the smallest possible motion. The corner of his mouth lifts, not quite a smile, as he glances at Victor and then at Rourke. The move is half reassurance, half assessment. an attorney cataloging strengths, weaknesses, and the sounds he will need to counter outside the room. He makes a marginal note in his brief and folds the paper with a precision that suggests rehearsal. The audio pilot changes incentives. Counsel choose words like they choose currency. Each syllable has consequence. Rourke cannot lean on a dramatic gesture to sell the ledger. He must name dates, amounts, and clinical indicators, and let the sequence of facts do the work. Lionel cannot rely on the image of his client in public to soften perceptions. He must craft rebuttal in tone and in timing. For the public listening at home, the feed compresses nuance into sound, an inhalation, a pause, a clipped denial, and those small elements become the texture of opinion. Rowan sets the procedural boundaries with a sentence sharpened to law. Counsel, she says, this proceeding will focus on risk and conditions. We will not allow material that is unduly inflammatory. Character evidence will be limited to matters relevant to bail. The words land like a gavel without the blow. A pencil stops moving in the hands of a junior counsel. Lionel's hand tightens fractionally around his pen. He exhales in a way the mic records as neutral but significant. There will be a fight, but it will be fought within a defined ring. Objections and stipulations are handled in low tones. Rourke moves through exhibits identifying the medical summary, the financial ledger, witness statements. Each designation is spoken in the clipped syntax of procedure. The cadence of someone who knows a jury will never hear this, but 1,000 strangers might. Maya notes entries with a steady hand, her pen translating the spoken record into a written one that will carry weight if questions arise later. Outside, the court's audio pilot ripples outward. Elected officials call aides, op-eds are drafted, activists set up meeting points. The feed's existence transforms courtroom arguments into early public arguments. That pressure does not change the law, but it changes strategy. Who is quoted? Which phrases are emphasized? Which facts are granted space? Defense counsel will plan statements for the public hearing room. Prosecutors will choose their language to avoid sensationalism and to keep the record solid. Rowan leans forward one more time, not to compel drama, but to command clarity. We will hear all relevant evidence, she says. We will hold this hearing to the scope of risk and conditions. Full hearing, no theatrics. The admonition curbs the impulse toward performance and reminds everyone, lawyers, client, press, that the process is meant to resolve a question, not inflame it. A witness list is called, the first name of the prosecution's specialist read out. The procedural machinery begins to move, subpoenas to witnesses, the call for exhibits, the scheduling of testimony. The microphones capture those small administrative steps, and they travel beyond the benchmark of the courthouse. The audio remains a strict medium. It prevents some theatrics and invites other forms of pressure. Listeners will parse an inhalation, a cough, a pause. Those micro moments will be debated on social feeds faster than any transcript can be filed. If you want to follow each testimony and the rulings that follow, subscribe for updates. The hearing will continue. The record is being made. Lionel Mercer stands as if he owns none of the room yet has every right to speak in it. He does not rush. He reaches for his folder with a single, deliberate motion, opens it, and lets his voice fall into the microphone, as if laying down a road for the court to travel. Your Honor, he says, we will show the court context. We will show Mr. Hale's commitments to the community and witnesses who can speak to his accessibility and character. He does not brandish emotion. He produces a small remote, presses it, and a soft mechanical click answers him. The room registers the sound even without an image on the feed. For a moment, the court fills with the echoes of applause, an editing artifact, the hushed suggestion of an image the audience outside will later see as footage. Lionel's words are measured, and his tone is warm. He lets the clip play long enough for the audio to carry that sense of ceremony. Applause, a clipped quote about service, a cadence that suggests a man at ease with praise. Rowan does not allow the theater to take root. She leans forward, picks up the rhythm from the bench, and speaks the ruling that trims the edge off performance. Counselor, character evidence is not admissible in a bail hearing. We are here to assess risk, flight risk and danger to the community. Her voice is controlled, precise. The sentence lands like a judicial blade, and the recorded silence that follows feels heavier for being recorded. There is a shift in Lionel's posture that is almost imperceptible. His fingers close over the edge of his folder. He does not argue the point aloud. He tucks away the remote and slides a witness list instead to the clerk. Rourke steps forward with his own quiet. Your Honor, he says, the concern is narrow. We ask that the court consider evidence only as it relates to risk and conditions. His voice is not an appeal to sentiment. It is an instruction to the record. He places into the transcript the medical summary, the ledger entries, and witness statements as narrow tools. He does not grandstand. He points to dates and figures. Victor's reaction to this exchange is small and calibrated. He tilts his head the slightest degree, the motion of a man who is measuring the air for threat and for advantage. His mouth twitches. It is not a smile meant for cameras. It is the currency of someone who has learned to be unreadable. For a second, his gaze sweeps the room and rests on Lionel, then flicks to Rourke. That motion, almost invisible on a first listen, registers in the margins of the audio. A chair creak, the scrape of a shoe. An associate in the defense table exhales quietly. Lionel shifts strategy. He calls witnesses whose testimony fits the limits the judge has set. A longtime employee takes the stand and speaks in concise sentences about schedules and presence. A charity director testifies to dates and locations of public commitments. Lionel conducts his questions like a craftsman, gentle prompts, slight corrections, a focused line of inquiry designed to place Mr. Hale within a frame of accessibility and predictability. Rourke's cross-examination is compact and exact. He does not throw a punch. He makes the witness answer specifics. Who arranged transportation? Who signed checks? Whether events required ID? Each question moves from general to precise until the edges of the story are exposed. The audio captures every inhale and every deliberate pause. At one point, a witness tells of a charity dinner where Mr. Hale briefly handed plates and spoke to volunteers. The telling is precise. Location, time, a sentence about presence. Lionel lets the detail hang for a beat, and the bench and the public pick it up like a bar of evidence. Someone in the gallery whispers. The microphones capture the whisper and the subtle uptick of a voice from a press table. That uptick will find its way into a morning report or a short clip on the evening feed. Tension sharpens when Rourke returns to the ledger. He reads a transfer and the date aloud. The clerk's fingers mark the line in the official packet. A cool, small sound. A pen cap removed, follows, then settles. Lionel's pencil scratches marginalia. He does not look up. He is cataloging. His hands move with purpose that signals confidence, not complacency. Rowan watches them with a judge's economy. Her interjections are rare and precise. When a defense line tries to cross the boundary into character advocacy, she interrupts and reclaims the scope of the hearing with a single phrase that clears the air like a bell. This proceeding will remain limited to the assessment of risk and conditions. Anything beyond that will be excluded. The room adjusts. Papers close. A man in the back adjusts his tie. The feed records the realignment. There is a moment of friction when Lionel, attempting to salvage narrative control, asks to play another clip for context. Rourke stands and objects. The exchange is polite on the surface, but it carries an edge. Lionel's hand taps the folder once, twice. Rourke's fingers fold white around his notes. The judge rules quickly, the sound of her gavel small on the recording, but decisive. Lionel yields, and in yielding he signals the next stage of his plan. Toward the end of the defense's allocated time, Lionel leans forward slightly, lowering his voice as if speaking to listeners at home, as much as to the room. "We will call a substantive witness tomorrow morning," he says. He pauses, then adds, "The witness is currently unavailable due to a prior commitment. We request a brief continuance." Rowan checks the time, her gaze flicking to the clerk, then back to Lionel. "Granted. We resume at 9 a.m. The words are plain, but the timing matters." Rourke's jaw tightens audibly. He makes a note. Rowan taps her pen, a small, audible measure that registers as attention rather than alarm. The clerk records the request and the hour. Lionel sits. Victor's motion is almost imperceptible, a hand smoothing a sleeve. The defense has placed public sympathy and curated facts into the record. The prosecution, clinical notes and ledger entries. The hearing is now a ledger of competing sounds, where strategy must meet proof and every word will soon be broken down into shareable clips for a public waiting to judge. If you think appearance equals innocence, tell us. Comment below. Michael Rourke stands and nods once to the clerk. "The prosecution calls the complainant," he says. "The formalities are quick. Oath, affirmation, the hush that makes speech the only thing in the room." Rourke begins with the facts. "State your name for the record." She answers. Her voice is low but direct. Rourke's questions are simple, chronological. "Where were you on the 21st? What happened that night? Did you seek medical attention?" The microphone carries the scrape of her page, the small inhale before a sentence. When Rourke asks if she kept a journal, she says yes. He hands her the copy the defense and prosecution both have examined. Rourke: "Read the entry you made that night." She turns the page with a shaky finger, steadies herself, and reads. "I tried to leave on the 21st, and he would not let me. He held my wrists. He said if I called anyone, he would make sure I could not open a bank account again. I could not breathe." The room holds. The audio feed catches the cadence and the weight of the final sentence. Rourke closes his binder slowly, as if to mark the space the words have occupied. Victor's reaction is immediate and contained. His left hand reaches, almost before thought, to the cuff of his sleeve and smooths it deliberately. An economy of motion that reads as disdain. Then just once his knuckle taps the bench, a tiny percussion that the microphone catches in the silence. It is like a punctuation mark, a private response recorded in public. The victim advocate does not remain passive. She stands, moves to the clerk's side, and slides a laminated contact card across the bench. A practical gesture for the record. "Probation outreach number, emergency contact protocol," she says quietly. The clerk nods and pockets the card. The action signals to the judge the possibility of immediate, concrete protection. Rourke turns to corroboration. "I'll show you the bank statement from the 22nd, he says, and places a printed page before the clerk. He reads dates aloud. Card access denied, accounts flagged, transfers that shift funds out of the complainant's control. The ledger is a series of small actions. When read straight through, they become a pattern. Lionel Mercer rises for cross-examination, approaching the witness with a soft, controlled motion, as if testing a key in a lock. "Ms. He begins. "You wrote these entries contemporaneously?" To his foundational questions, her answers are short and firm. Yes. She had written them contemporaneously. Yes, she had written them herself. No, she had never forwarded them to a bank or a friend at the time. Lionel's questions then move from the obvious to the quietly insinuating. He leans in, lowering his voice so the microphones pick up the intimacy. "When you tried to use your card and it did not work," he asks, "did you receive an automated message from the bank?" "No," the witness replies. "I just tried to use it, and it failed." "If a bank freezes an account," Lionel presses, "is it possible the bank itself or a trustee could have acted without Mr. Hale's knowledge?" Rourke is on his feet immediately. "Objection, Your Honor. Calls for speculation and invites the witness to opine about bank procedure she has not observed." Rowan's voice cuts in, directed at Lionel. "Counselor, foundation." "Your Honor, I will establish foundation," Lionel says, turning back to the witness. "Did you receive any notice from the bank that your access had changed?" "No, I did not," she answers. "Who did you contact when you discovered you could not access funds?" "I called customer service. Later." "And did customer service tell you why?" Lionel continues. "They said we needed more verification." Rowan interjects, her ruling precise. "Sustained to the extent the witness cannot speculate about third-party procedures, limited to what the witness personally observed and was told." "Understood, Your Honor," Lionel concedes. Rourke steps in on redirect like a surgeon completing a stitch. "Ms. Did you preserve any messages from your bank?" "Yes," she confirms. "Will you identify those for the record?" Rourke asks. He places a printout before the clerk showing emails stamped with dates and the complainant's phone number attached. He addresses the bench. "We have correspondence that shows attempts to notify. We have call logs. Those items will be entered as exhibits." The moment sharpens. Lionel leans back slightly, the plan he had to introduce administrative explanations momentarily narrowed. He does not flinch outwardly. His pencil makes a new mark. The prosecution calls a forensic nurse. Her testimony is clinical, precise. "Strangulation produces observable markers," she says. "Ligature marks, petechial hemorrhage in the eyes and face are common, and airway compromise can be delayed." Rourke: "Did you observe markers consistent with external neck compression?" Nurse: "Yes. Consistent with compression and with the complainant's description." The nurse's voice is even. The implication is not sensational but unavoidable. Lionel's cross is careful. He asks whether the nurse can specify an exact cause beyond visible harm. He asks if internal imaging was performed and whether the nurse saw results. The nurse answers within her scope. Some tests were scheduled, some results were pending. At one point, Lionel raises a question that has a different tone, less about systems and more about memory. When you wrote, "I could not breathe," can you tell the court whether you described a sensation you could later identify medically, or whether it was the sensation at the time? The witness pauses, then replies, "It was the sensation at the time. I remember the pressure and the panic." Rourke's rebuttal is immediate and documentary. He reads from EMS notes and hospital intake forms with dates that match the journal entries. "We have contemporaneous medical records," he says, "and communication logs showing attempts to reach the complainant's phone at the times cited. The documents are granted into the record and the ledger tightens. There is a small eruption when Lionel seeks to introduce a charity roster suggesting volunteers could have made arrangements for events. Rourke objects that the roster is collateral and irrelevant to the bail issue. Rowan rules that limited context is allowed, but that the roster cannot be used to imply routine presence equals non-risk. The judge's voice cuts cleanly through the debate. The audio feed records the strains, a pen scratch, a throat clearing, an intake of breath. Outside, phones ping as statements are drafted. Inside, the record is what matters. Rourke folds his notes and looks once to the complainant with a small human expression of resolve. Lionel closes his file and nods to his client. Victor smooths his cuff again, this time with a deliberate motion that reads like ritual. Rowan addresses the room. "The court will consider these items in determining appropriate conditions," she says. "We will proceed on to the next witness." The microphones pick up the tap of the clerk's pen as entries are made. The hearing continues. If you were affected by the testimony today, consider sharing the conversation so the public can hear how these decisions are being made. The hearing will resume. The court calls the forensic risk analyst. He sets a laptop on the lectern and speaks with the economy of someone who turns complex webs into numbered likelihoods. "Your Honor," he says, "my models identify predictors of reoffense and flight. Strangulation is a high-risk indicator." He explains, in plain terms, how clinical findings translate into increased probability of future violence. The language is clinical, but its implication is stark. He brings up an influence map, nodes for trustees, shell companies, recurring vendors, and named intermediaries that blur direct responsibility. He speaks of payment flows that obscure a principal's hand and of proxies who shield direct contact. The description reads like a maze. At the defense table, Lionel's hand moves once, almost invisibly. At the dock, Victor's chin lifts a fraction, a small, controlled signal that registers as composure and calculation. The micro-motions are tiny, but the room notices. Rowan hears the implication and cuts in. "Counselor," she says, "I will hear methodology. Limit testimony to demonstrable links relevant to flight risk and danger to community. However, testimony about political connections or speculative influence networks must be limited to concrete evidence showing how those connections could facilitate evasion or contact with the victim." This hearing addresses risk, not political theory. He returns to concrete lines. He points to a trustee who signed transfers on specific dates. He traces a corporate entity that received funds coinciding with account freezes. He identifies an intermediary who arranged deliveries to the complainant's address on dates when movement was constrained. These are not conjecture. They are entries on a ledger. Lionel rises slowly. He does not attack the expert personally, but he presses the edges of the model. "Mr. Analyst," Lionel asks, "how do you account for false positives in your model?" Could a series of unrelated administrative errors look like a pattern to an algorithm? His voice is precise. The question aims to temper certainty. The analyst answers carefully. Models carry error bands, he says. We test for noise. But when clinical indicators, contemporaneous journal entries, and financial traces align, the signal strengthens. The model quantifies probability. It does not assert causation. His answer is sober. It concedes limits while standing by the weight of converging data. Then the analyst turns to mitigation and limitations. GPS monitoring is useful, he says, but it is not foolproof. Monitors can be swapped, signals can be obscured, and third parties can be used to maintain contact. Probation is effective within capacity, but capacity is finite. He gestures to a section of his report labeled points of evasion and names the practical vulnerabilities. A probation officer called to the stand speaks up with a tone that carries fatigue and concern. We try to respond quickly, he says, voice threaded with urgency. But we are human. We have caseloads. When a signal drops, we verify. That verification window can be exploited. We can do better with resources. But right now, there are limits. The officer's words are not abstract. They read as a quiet alarm. The analyst lists mitigations, redundant monitoring, immediate verified alerts, a designated victim advocate to receive notices, and protocols for securing accounts. He notes costs and logistics, who pays for monitoring, who maintains the alert center, who coordinates cross-jurisdiction responses. Outside the formalities, the political machinery stirs. A soft murmur moves through the gallery. A staffer in the back of the room taps a message into a phone. The public conversations that will follow are not the court's business, but they will press on the court's practical choices. The expert's closing line is simple and heavy. Technology reduces probability. It does not eliminate risk. Enforcement and resources determine whether mitigation is effective. The sentence leaves a weight in the air. Rowan exhales once, then taps her pen against the pad in 2 slow beats. Her hand does not tremble. The gesture is a small, audible measure of the gravity she bears, not for headlines but for lives. Noted, she says. Mr. Rourke, provide proposed language for monitoring, notification, and responsibility for costs. Mr. Mercer, be prepared to address feasibility. Her direction is procedural and immediate. It moves the hearing from descriptive analysis to actionable options. The analyst closes his laptop. The projection powers down with a soft click. The court moves on to logistics. Who pays, who answers, and who enforces. The influence map has been useful. The point of the hearing is now to convert that map into conditions that can be enforced where enforcement matters. Can technology and process be coupled effectively to prevent evasion? The courthouse sleeps, but the story does not. By night, the audio feed, intended for transparency, mutates into something else. Testimony is chopped, remixed, captioned. The victim's voice becomes an echo laid over background music. Her pain becomes content. Hashtags divide the map again. Keep us safe against Tasher Free Hail. The split is complete. In a small apartment across town, the woman whose voice started it all scrolls through her phone. She sees her face frozen mid-laugh from a dinner 2 months after the assault, cut from context, rebranded as proof. The caption reads, "So terrified she's out celebrating?" Her hand trembles once, then steadies. She closes the screen, turns the phone face down, and whispers to the empty room, "They took my voice again." Meanwhile, Lionel Mercer's office glows blue from screens. He stands behind two junior associates editing a 60-second clip. Victor at a charity gala, voice calm, suit immaculate. "Keep the piano track soft," Lionel says. He sounds better against sincerity. The video posts at dawn. The caption, the key, "Everyone deserves due process." By midday, it trends. Influencers move fast. A true crime podcaster records a breakdown episode. A lifestyle vlogger posts a video titled, "When Empathy Goes Too Far." A political commentator tweets, "If the courts can't stay neutral, maybe the crowd should." Each clip reshapes the case. At the prosecutor's office, ADA Michael Rourke watches the screen flicker through statements, denials, and reaction shots. Maya leans on the desk beside him. "They're making him a symbol." Rourke replies, "Symbols don't show evidence." He reaches for his phone, scrolls through contact names, and calls the court's communications director. "Draft a short statement," he says. "No spin, just the record, evidence presented, testimony heard. We'll post it through the official channel before noon." It's a small move, but it's a counter. His job is not to win the war of words, but to remind the public what counts as truth. The anonymous video surfaces that night. Shaky footage, the victim laughing, timestamp cropped. It detonates online. News shows air it in endless loops. Comment sections turn venomous. In the prosecution office, a technician shakes his head. "No metadata, no origin. Can't authenticate." Rourke nods. "Then we don't respond with outrage. We respond with facts." He drafts a motion to have any unverified digital materials formally excluded from the record. A legal move. Quiet, but precise. Lionel gives his own statement outside the courthouse. "I have no comment on unverified material," he says, calm as marble, "but I believe in full context." He doesn't deny, doesn't confirm, just leaves the phrase full context hanging long enough for the cameras to catch it. The next morning, the courtroom feels different. Every lawyer knows that beyond the microphones, there are millions of listeners waiting for the next soundbite. Rowan notices it the moment she enters. Phones flicker in the gallery, faces half lit by screens. The hum of digital life sits beneath the silence. She looks up and says, "All devices off or out of the room. The law will not compete with commentary." The sentence is firm, but her eyes move once toward the ceiling microphone. The same feed that gave the case its reach and its distortion. When the hearing recesses, Maya whispers, "They're saying online that the judge's tone favors the defense." Rowan exhales quietly, fingers resting on the bench. "Tone isn't bias," she murmurs, "but try explaining that to an algorithm." It's the closest she'll come to complaint. Outside, the press pushes. "Judge Rowan, are you feeling political pressure?" She doesn't stop. She walks past the lights, steps into her car, and shuts the door. The click of the latch cuts off the noise. For a moment, the glass holds silence. She sits still, eyes closed, and the weight of public scrutiny settles on her shoulders like a second robe. Back at her apartment, the victim lies awake. The sound of her own laughter, ripped from that anonymous clip, still playing faintly from someone's phone in the street below. She pulls the pillow over her ears, as if to silence a voice that no longer belongs to her. The world keeps talking. The system keeps spinning. Every side claims truth. Free or safe? That question started it. Now it's become something else entirely. Who controls the story now? Comment your answer below. Rowan sits behind the bench and lets the room breathe around her. The microphones pick up small noises, the tap of a pen, the shuffle of paper, but behind those sounds a memory edges in, precise and quiet. It is the smell of coffee and bleach in a hospital corridor, a child's hand held too late in a photo that ran under a headline. The file she signed then had looked clean on paper. Conditions suggested. Promises of supervision. The next day, the headline said otherwise. The memory is not a replay. It is a single, sharp detail, a judge's pen slipping on a line that would not be undone. Her hand goes to her glasses and slides them down the bridge of her nose. For the first time that morning, her fingers press a fraction harder on the frame, a near imperceptible tightening. Maya stands near the bench, folder in hand. She watches Rowan the way someone reads weather, quietly, looking for signs. "Do you want me to call the advocate now, Judge?" she asks. Rowan looks up. Her eyes have the steady clarity of someone who has read more files than headlines. She nods once. "Yes," she says. "Confirm outreach. Get the contact on the record." Her voice is even, but when she speaks, she lets her gaze rest on Rourke for a fraction of a second, a quiet underscoring of what she means. It's not enough to order conditions. They must be enforceable. Maya notices the look. She does not only take orders, she reads their weight. Her hand closes briefly around the folder, notched with a finger where she will make the call. "I'll do it now," she replies. The hearing resumes, and the room reclaims its rhythm. Witnesses, questions, pen strokes. But the memory leaves a mark in the smallest places. When a clerk misreads a date, Rowan corrects it with a fingertip and a curt note. When Rourke summarizes the ledger, she listens not only for facts, but for how those facts could be operationalized. Who enforces, who answers alerts, who tracks payments. A witness stumbles over a time frame. Before the question settles, Rowan leans forward and asks for a precise date and account name. At recess, she walks the short corridor to chambers. The building air is stone cool. For a moment, a muffled protest chant filters through the vents, a single stretched note that returns like an echo. Rowan pauses, breathes, and lets the echo recede. Back on the bench, she scribbles 3 words at the top of her notes. "Cannot risk this." The handwriting is quick and private, a posture in ink. Maya glances at the page and reads the phrase without surprise. The clerk knows the difference between legal theory and what keeps a person safe in practice. Rowan addresses counsel with a clarity shaped by experience. "The court will consider whether ordered conditions can be enforced in practice," she says, and her gaze flicks again toward Rourke. "I want specifics. Who monitors how alerts are verified and who bears the cost?" The instruction is direct. It is the voice of someone who has seen promises fail. When proceedings adjourn, Rowan hands Maya a short list of tasks and a single instruction. Confirm the victim advocate's availability and verify the probation office's monitoring protocol in writing. The tasks are procedural, but they are also an answer, a way she turns memory into measures. Does personal experience have a place in judicial judgment? The question hangs in the air like a faint echo. If you think personal experience should influence judicial decisions, share your view in the comments. Michael Rourke rises with the quiet focus of someone who has already rehearsed the scaffolding of his argument. He approaches the lectern and lays out, plainly and without flourish, the package he asks the court to order. "Your Honor," he says, "Your Honor," he says, "under the State Bail Reform Act and pursuant to Penal Code Section 1275, which grants this court authority to impose conditions necessary to protect victims of domestic violence, the prosecution requests the following conditions based on the defendant's demonstrated flight risk and substantial danger to the victim. He continues, $5 million secured by deposit or equivalent collateral, immediate surrender of passport and strict travel restrictions, GPS ankle monitoring with daily automated reporting to probation, a formal restraining order, mandatory enrollment in a state-certified batterer intervention program as a pre-trial condition, with proof of enrollment provided within 72 hours, and designation of a victim advocate who will receive 24-hour notifications of any verified alert or attempted contact. Rowan listens without interruption. Her pen waits like a metronome. "Mr. Rourke," she says, "identify who will serve as the victim advocate. Define verified alert. Specify the reporting cadence to probation and clarify who bears the cost of monitoring." He looks up and meets the bench calmly. "We propose the prosecution's victim advocate for coordination, Your Honor. A verified alert will be defined by confirmed GPS tampering or proximity violations, corroborated by monitoring logs or police. For costs, we request the defendant be ordered to pay. Given the defendant's substantial financial resources, we believe he has the clear ability to pay. However, if monitoring services are interrupted due to non-payment, we request the court authorize immediate bail revocation." Lionel Mercer rises at once, folding his hands like a man who prefers precision to showmanship. "Your Honor," he says, "we share a concern for safety. My objections are procedural. First, the definition of verified must be narrowly drawn to avoid false positives. Second, an immediate forfeiture mechanism risks disproportionate loss before the defendant can meaningfully contest an allegation. Third, ordering the defendant to pay monitoring costs before any finding of culpability is prejudicial where alternatives exist." Rourke's gaze meets Mercer's across the room as he replies. The look is small but charged. No raised voices, just the legal equivalent of a pointed exhale. "Counselor," Rourke says, "expedited hearings must be meaningful. Our proposed window is 24 to 48 hours for an initial verification hearing, so the state can act quickly when there is imminent danger, but defendants retain the right to contest. The goal is not to create a formality. It is to provide a rapid, fair mechanism to protect a potential victim." Rowan taps her pen 2 quick times. The sound is audible in the hush. "Mr. Mercer, Mr. Rourke," she says, "the court will adopt a show cause process. 48 hours will be the outer limit for an initial hearing on a verified alert. In cases where law enforcement confirms imminent threat, the court reserves authority to act immediately." She lets the sentence settle, then adds a micro beat, a brief tightening at the corner of her jaw that registers as quiet steel. "I want the victim advocate designated in the order, with direct contact information on the record. Probation must receive daily automated reports and real-time verified alerts." Rowan's pen scratches once, deliberately. The court finds, under State Penal Code, Section 273.5 and 273.6, and consistent with the principles established in United States v. Salerno, that the defendant poses a demonstrable risk to the victim's safety. The evidence of strangulation and financial coercion establishes a pattern of escalating violence. The conditions I impose are narrowly tailored to address that specific risk while respecting the defendant's constitutional right to reasonable bail. She pauses. "The court will not act mechanically," she says. Bail revocation will require a show cause hearing. The initial hearing window is 48 hours, except where verified imminent danger justifies immediate custody. The court will draft specific language to ensure the process is neither perfunctory nor prejudicial. Rourke then addresses costs, noting the industry requires immediate funding. Lionel counters, allow the state to cover initial costs under a standing fund with reimbursement ordered only on final adjudication. That protects both safety and due process. Rowan looks between counsel, then back to the file. Prepare proposed language, she instructs. Include the scope of verification, the timetable for expedited hearings, and the mechanism for funding and reimbursement. Rourke takes a breath, and then adds a final operational point. Your Honor, because indirect contact through intermediaries is a documented risk, the court should include a prohibition on third-party communications intended to circumvent the restraining order, with a defined evidentiary threshold for treating such communications as direct violations. Rowan inclines her head and sets the boundary plainly. The order will include a prohibition on third-party communications shown by documentary or testimonial evidence, such as transaction records, text messages, emails, or witness statements, to be at the defendant's direction. This includes, but is not limited to, gifts, payments, messages, or requests delivered through intermediaries to the protected party or her immediate family, where evidence shows the defendant initiated or directed such contact. Rourke nods in agreement. He then turns to the prosecution table and submits the drafted conditions. Lionel signals for time to confer with his client. Victor Hale in the dock signs the acknowledgment the clerk places before him. The sound of his pen on paper is sharp in the room, precise and final. At that exact moment, a phone on the defense table pings. The single tone breaks the hush. Victor glances down, then carefully tucks his hand under the table so the screen is not visible. The movement is practiced. The ping hangs in the air like a question. Rowan looks up, a thin line of firmness passing across her features. She leans slightly forward. Because the record shows risk of indirect contact, she says, the order will expressly prohibit gifts, payments, or messages sent through third parties if those acts are shown to be intended to circumvent the restraining order. Counsel shall draft concrete language. This order must be operational. If any element cannot be enforced, counsel must notify the court immediately. The gavel falls softly. As the room disperses, the single ping from the defense table remains an echo in the air. Outside, the public will debate whether the package is sufficient. Inside, the court has fashioned an order that aims to be both protective and precise. Is this package strong enough? Comment below. The orders are still warm when the work begins. The ankle monitor is clamped on in a small administrative room off the courthouse. The LED blinks twice. A tone confirms the link. The clerk files the receipt for the surrendered passport. Banks confirm holds. The court's words move from paper to practice. Probation's dashboard lights up. Officer Diaz watches a map of tiny pings that trace Victor Hale's day. He reads the green dot, then the slow line of movement that shows a man leaving home, stopping at a cafe, and then pulsing at an office location downtown. Diaz taps his pen against his notebook and thinks one bureaucratic thought that stays with him. This system won't stop him. It will only tell us where to look when something goes wrong. The thought is private, practical, and the kind that makes a night shift officer schedule extra verification checks. The report pings again. The dot jumps. Residence to 45 Wall Street. Diaz dials the verification line for protocol. Mr. Hale, this is Officer Diaz with probation. Report your location, please. Meeting with counsel, comes the calm reply. Diaz logs the confirmation as a non-violation, but flags it. The protocol works because someone answers. The monitor does not prevent the meeting, it creates a recorded trace that can be used later. Pressure comes in subtler forms. That afternoon, the complainant's building manager reports a small delivery left at the concierge desk. A single white camellia wrapped with a hand-tied ribbon. The complainant had mentioned camellias once in passing, a private reference to an anniversary kept between them. The victim advocate photographs the flower, catalogs it, and forwards the image to probation. Not illegal on its face, the advocate says into the record, but it's a targeted message. The delivery reads like intimacy, weaponized, an indirect contact that carries meaning only the recipient would know. Other proxy contacts show similar windows into proximity, a courier bearing an unsigned note claiming it was from a concerned colleague, a landscaper who reports seeing a man nearby at a time the monitor shows a ping, a friend offering to run an errand and then turning up at the complainant's building. Each incident is logged, time-stamped, correlated with monitor data. Alone, none compels action. Together, they form a pattern. Then, a new element arrives at the prosecutor's inbox, an anonymous attachment that clangs like a bell in a quiet office. Michael Rourke opens it at his desk. Inside, cropped bank screenshots, a PDF of transfers, and a single odd image. A photographed receipt showing a wire to an entity named Nightingale Holdings, with a memo line that reads, hand-scrawled, Trust Distribution. The name means nothing to Rourke at first, but a quick search shows no public filings, no registered agent in the U.S., classic shell company markers. There is also a small, low-resolution photo of a stamped corporate seal on a sheet of paper and a thumbnail of a document with a scribbled note, Czech Shell Company, Cayman. The file is clean of headers. No metadata, no originating IP, no sender trace. Rourke looks up at Maya and says, "We can't admit this as evidence without a chain of custody, but it's a lead." He calls the cyber forensics team and asks them to chase server logs, then emails the bank liaison for confirmation of the transfer. He logs his request to the financial crimes unit. Even as he moves, Rourke knows the split truth of these things. An unverified file can be dismissed in court, yet it can explode in the court of public opinion. He folds the file shut and writes one terse note at the top. Verify source. Corroborate transfers. The first 72 hours become a pressure test. Monitors blink, flowers are photographed, verification calls are logged, and an anonymous file sits on a prosecutor's desk waiting to be traced. The court's order has begun to breathe, and the first breath has already revealed how many tiny cracks the system must seal. Comment. Part 2, if you want the verification trace followed up. The room holds its breath as clerks move the last docket into the record. Judge Rowan rests her hands on the bench and reads once, slowly, the line that will outlive the paperwork. Freedom on paper isn't freedom in practice, she says. The sentence drops into the feed and hangs there, simple and immovable. The court has set enforceable conditions intended to make that liberty meaningful. If an element cannot be implemented as written, counsel must notify the court immediately. She does not recite the checklist again. The order is on the record. The work is now in execution. The ankle monitor's green light blinks like a small promise. The victim advocate's card is filed. The court's mechanisms are engaged. At the prosecution table, Michael Rourke is not idle. An encrypted message pings on his phone, a terse line from cyber forensics. He opens it and reads, eyes narrowing. The forensic note is brief but clear. Registry check confirms an entity, Nightingale Holdings, registered in the Cayman Islands. An initial IP trace resolves to an anonymizing proxy. One transfer in the attached file matches an outbound wire to an account tied to that entity. Rourke folds the printed note, then leans toward Maya. His voice is low, urgent. They've confirmed the shell is real. I need a warrant to follow the money and a preservation order sent to the bank and the server host now. A preservation order prevents destruction of records while the warrant process moves forward. He taps commands into his tablet. Draft for preservation. Request for expedited subpoena. Copy to financial crimes. Maya moves with the quiet speed of someone who knows which buttons to press. She prints the preservation template, stamps the file, and slides it to Rourke. The prosecutor marks the document, initials it, and the motion begins to form, procedure becoming action. Across the room, Victor Hale's phone vibrates on the defense table. The single buzz cuts the hush. He glances down, a micro-expression passing, almost a smile, almost a calculation. The screen shows a single line. Confirmed. No sender name. He tucks the phone under his notes as if to hide a small victory. The movement is economy itself, minimal, practiced, and the sort of thing that the audio feed registers as a soft punctuation. Rowan watches the room with the patience of someone who reads motion as motive. She notes the exchange between Rourke and Maya in a way the microphones don't carry, an acknowledgement, not a rebuke. Her role is not to intervene in investigations. It is to keep the process tight and lawful. Rourke slides the preliminary forensic printout back into his folder and closes it with a soft, decisive snap. We'll proceed by the book, he says aloud, though not theatrically. Preservation order, request for warrant, coordinate with cyber forensics, and the bank liaison. If the trace yields a server, we go for a warrant immediately. The steps are legal, immediate, and binary. Follow the paper, secure the data, stay within chain of custody. The room exhales a little as the gears begin to turn. Rowan taps the gavel once, soft but final. This matter remains under the court's supervision, she says. The record will reflect these actions. Court is adjourned. As people stand, the green light of the monitor continues to blink. The anonymous scrap that led to a Cayman note sits now in a file stamped for action. The phone tucked beneath papers is quiet for the moment, but its brief vibration has added a new urgency to the air. Comment Part 2 and share if you want the trace followed. This is not just one case. It is the system itself on trial. Justice, truth, and the line between freedom and safety, these questions are not only for the court. They are for all of us. The final judgment rests not only with the judge, but with you. Subscribe to JusticeSoul and turn on notifications to follow every development. Be part of the verdict.